Courts in session, phones on silent, brains on. On July 1st, the Justice Department told America that law-abiding Virginians face criminal sanctions simply for possessing the guns they already own. Possessing, owning, just having them in the closet, a terrifying thing to say to a jury, and a real scandal if it were true. So let's do what nobody in that press room did. Let's read the file. Here is the charge in one sentence, so nobody says I paraphrased. Assistant Attorney General Harmeet Dillon, announcing a federal lawsuit against Virginia, said Americans should not face criminal sanction for simply exercising their right to possess arms. The acting Attorney General added that the Second Amendment is not a second-class right. Notice the load-bearing word, possess. Everything the department wants you to feel rides on that one word. So let's test it, exhibit by exhibit. Exhibit A. What the law actually does. Virginia's statute bans the sale, the purchase, the transfer, the import, and the manufacture of the firearms it covers, plus magazines over 15 rounds. Read that list twice because possession is not on it. Every gun and magazine a Virginian already owns is grandfathered. Richmond's own CBS affiliate put it plainly. Guns and magazines already owned by Virginians would not be impacted. Nobody in Virginia faces criminal sanction for possessing a thing they already own. Let the record reflect it. And this is not my reading. The Reload, an outlet that covers gun rights for a living, says it just as flatly. The law bans sales, not possession. So the statute says it. A gun rights outlet says it. And still the press release says possess. Hold that gap in your mind, jury, because I am about to introduce the one witness the department cannot cross-examine, itself. Exhibit B, the department's own complaint. Same building, same day. When the Justice Department stopped writing for the cameras and started writing for a judge, the words changed. The complaint says the law makes the commercial purchase of AR-15 style rifles a crime. Purchase. Commercial purchase. The document filed under a lawyer's professional obligations says purchase, and the document filed under a press secretary's obligations, which are none, says possess. Only one of them is signed by somebody who can be sanctioned for lying to a court. Now put the two exhibits side by side, because this is the whole case. The press release for the public says possess. The complaint for the court says purchase. Those are not two words for the same thing. One is a man who owns a rifle. The other is a man at a gun store counter who cannot buy a new one. The department told the public the first man is in danger. Its own filing describes only the second. That is the difference between owning your car and being told the dealership is closed. So, who benefits from saying possess instead of purchase? A purchase ban is a policy fight, and a reasonable person can land on either side of it. But possession, coming for the guns you already own, that is the phrase that raises money, fills inboxes, and turns a dry commerce statute into a knock at your door at midnight. The honest word describes the law. The scary word moves the base. They picked the scary word on purpose, and they put it in the press release, not the part a judge would read. And here is where I get fair, because a prosecutor who only tells one side is just a press secretary with a nicer office. The department is completely entitled to argue that even a purchase ban is unconstitutional. That is a legitimate legal position. One day before this suit, on June 30th, the Supreme Court agreed to decide whether the Second Amendment even protects semiautomatic rifles like the AR-15. The department might win that argument, and the ban would fall on the merits. That is the honest fight, and it is the one they were allowed to pick. 2 more dates undercut the panic. Since the Bruin decision in 2022, every federal appeals court to rule on bans like this one has upheld them. 3 circuits up, 0 circuits down. The question is open, not settled. And there is one more date the press release forgot to mention. On June 25th, a Virginia state judge already blocked the sales ban through at least the end of the year. So when the department sued to stop this law from being enforced, the law was not being enforced. They sued to stop a train that a judge had already parked. So here is the verdict, and I am only ruling on the framing because the lawsuit belongs to the courts. The Justice Department is allowed to argue Virginia's ban is unconstitutional. It is not allowed to tell the public that people can be jailed for owning what they already own, when its own complaint, filed the same day, says the law bans a purchase. That is not a lawsuit. That is a press release that couldn't pass the bar exam its own filing had to. On the framing, the verdict is misleading, and the impeaching witness is the department's own complaint. I'm Madeline, and this is Pixel Politics.